Correct, my lady.
And for this position of High Court judge, we are interviewing about 100 candidates. And we require 20. And given your professional life, from the date you are admitted, can you tell us what you've been doing and relate it to the position that you've applied for of a judge? So for the last 17 years, what is it that you've been doing that is relevant to this position? In about 2 or 3 minutes.
Thank you, my lady. First of all, Honorable Chief Justice, Commissioners, thank you. I hold a master's degree in human rights law, both from the University of South Africa. I hold an LLB degree from Moi University and a postgraduate diploma from the Kenya School of Law. My personal values, let me just highlight on that, are number one, relationships. I'm very intentional about my relationships with God and people. My second value is integrity. I observe that in my public and private life. My third value is continuous learning. I encourage myself to ensure that I upscale.
I don't want to appear like I'm interrupting you, but yes, those questions will come in at some point.
Yes. But
for now, we just wanted you to relate your professional life vis-a-vis this job that you've applied for.
Correct. Let me proceed to do that. I understand the work of a judge to entail two broad functions, my lady and commissioners. The first function is judicial in nature, which involves the ability of a judge to hear a matter, write a ruling that is, or a judgment that is consistent with the law. And for a judge to be able to do that, then they must have the professional competence required. They must have a deep understanding of the law. My 17 years of practice, my 17 years of being an active participant in our court corridors, also as an academic and also as an in-house counsel, has given me the professional competence to be able to discharge that function. I bring with me research and writing skills. I bring with me practical experience from the courts, and I believe those are the skills that a judge would need to be able to do the judicial part of the work. The other side of the work that I understand a judge does is largely administrative. And I want to say that in all the places that I have worked, Honorable Commissioner, I have always held leadership positions. And I believe that a judge should be able, for example, to put together a team that would be able to achieve certain objectives in the station that he or she works. I believe because of my leadership abilities, I am able to put together a team that can achieve certain objectives. If it's case management, if it's dealing with backlog, if it's motivating the staff to achieve certain outcomes, I have the ability to inspire people to work towards achieving those objectives. I believe I have those competencies, and I believe they'll add value to the office of the Judge of the High Court of Kenya.
Right, Wakili, I'm really trying to understand what you've been doing for the last 17 years, and I can break it down further for you and ask you this question. How does your day job look like?
My lady, at the law firm, my day job looks like this. I have to understand what we want to achieve in court on a daily basis with my team. I work with a team of about 6 lawyers. I'm the lead partner in a law firm that has 2 locations, one in Nairobi, the other one in Bungoma County. So on a daily basis, I must know what we want to achieve for that day. I must align my team to achieve those objectives. We must know who is attending to which matter. There are matters that I handle myself. There are others that the other team members handle. And on a daily basis, I must have that information with me. So we do strategy meetings every morning to align ourselves to the objectives that we want to achieve on a daily basis. We also leverage on technology. If I'm in Nairobi, then I'm able to do a meeting with my team in Bungoma and agree on the objectives that we need to achieve.
All right. As a legal firm, any special area of focus in terms of specialization of the law?
The law firm that we run is, I would call it a general purpose law firm. We mostly support corporate clients in banking and insurance. So bulk, about 80% of the work that we do is within that spectrum.
All right. Now that you've expressed the desire to join the judiciary in the capacity of a judge, and you being a practitioner, I'm sure over a period of time you've observed certain things that you think if you become a judge, you would not want to be that kind of a judge. What are these?
My lady, the first thing that I have observed in our courts is the problem of backlog. It continues to be a problem even today. As a judge, the first thing that I'll do when I report to work, by God's grace, is I will seek to understand how many matters are within my docket. And I intend, and I believe that the CTS system of the judiciary will be able to tell me how many matters are there allocated to me. And I will seek to understand when these matters were filed, the progress made in these matters, and I'll seek to understand why, for example, some matters are stuck and they are not progressing. If there are matters that need notices to show cause to be issued, I will do that. If there are matters that need advocates to appear before me and take pretrial directions on how to expedite with the matters, we shall do that. If there are matters that we can refer for mediation, we will do that. We'll refer them to mediation. If there are matters that, for example, need to be referred for AJS, we'll refer them to AJS. If there are matters that are dead, because I believe sometimes there are matters that are filed by litigants, and for some reason, the issue is actually resolved out of court. Perhaps somebody passes away. Perhaps as a family they sit down and resolve the matter, but they forget to report back to the judiciary that we have resolved the matter. So I believe there are also some dead cases within our registries that need to be closed.
Wakili, I was very specific, and please try as much as possible not to answer your own question,
Yes.
but to answer the question that you're being asked. The question was, what is it that over a period of time you've observed that you think if you become a judge, you will want to do differently?
And so I'm talking about the issue of backlog. And
how would you want to do that differently?
I would want to use the strategies that I have just said, and also get together the team at the registry to help us decongest the registry by making sure that these matters are actually dealt with. The second issue that I have seen as a challenge in our court systems is what I would call lack of progress in a matter, in this sense, Judge, that for instance, we appear before a judicial officer and the other side files a preliminary objection. On the face of it, we can see that it's a preliminary objection that's heading nowhere. I have seen other judicial officers engaging the advocates and asking them to explain why they have filed the preliminary objection. And out of that conversation, sometimes somebody withdraws whatever objection they have filed because they can see that they were wasting the court's time. So I would be a proactive judge who will look at whatever is before me and engage the advocates.
So just in a summary form, what special attributes do you bring to the judiciary that would definitely make a difference in the dispensation of justice?
I bring with me the culture of discipline. I'm a disciplined person. I set goals and achieve them. I bring with me a wealth of knowledge from my 17 years of practice, both as an in-house counsel, in academia, and also in practice. I bring with me the experience that I've gotten from research and publications. And with that, I think I would be a good judge who will build indigenous jurisprudence, a judge who will develop the law through my judgments and rulings. I'll be a judge who will be very sensitive to the current vision that the judiciary is pursuing, that is social transformation through access to justice.
Thank you very much. That's all from me.
Thank you, my lady. Yeah.
Looking at your CV, and you know, you seem to be in very many areas at the same time. Now, my first question would be, what is the key driver in your quest for this position of becoming a judge? Because, you know, you're already doing so many things right now. You want to become a judge. I don't know what is really driving you into it.
Thank you. Thank you, Commissioner. My driving force is really to serve this country as a public officer. I've always wanted to serve because one of the things that drives me is giving back to community. And I look at this opportunity as a way to define public service, to do it on a much more defined and higher scale. I was brought up with a very high sense of giving back to community, to the extent that sometimes we'd fix a public road and, you know, it's a local authority that's supposed to fix it. And we understood that we don't exist in a vacuum, but when you get certain competencies and skills, you need to find a way in which you can give back to community. So I believe that the experience and the training I have gotten over the 17 years that I've been in the legal profession, I can use this to give back to society as a judge of the High Court of Kenya and to serve Kenyans at that position. So that is my driving force, really to serve public service.
Yeah, but you see, one may say that's a generic answer because you can serve in many other ways, not necessarily as a judge.
Yes.
And even where you are, you're still serving, you know, when you lecture, when you, give your advocacy skills, when you consult, that's still service, you know. So, I'm still not getting, when it comes not specifically wanting to cross over to becoming a judge.
Yes, ma'am.
What is it?
Yes, apart from service, I also feel where I have reached in my career, I have something that I can contribute in terms of developing jurisprudence. I find that a very interesting space that I would like to be in. I've been inspired by judgments and rulings of people like Justice Mumbi Ngugi, who started the whole debate about structural interdicts. And I want to be that judge who develops jurisprudence, who develops the law, who moves, who helps us break free from what I would call unprogressive precedent and develop a country through jurisprudence that the Constitution contemplates. So that is another thing that has inspired me to apply for this position, Commissioner.
Now, I don't know that you've read a book by somebody called David Rubenstein, How to Lead.
I haven't read that book, Commissioner.
Right. Now, I'll tell you what he says.
Yes.
That one of the key attributes of being a good leader is developing very specific skills in one particular area. You know, very specific skills in one particular area, not being all over the map. Nothing wrong with being all over the map. You know, people are different. Now, which brings me now to the question. You see, I'm struggling to understand, with tremendous respect, and
Yes.
I'm not saying there's anything wrong with that,
Commissioner.
which is your area of speciality, where you feel well grounded. Because I see in your CV, you seem to be in consulting. You know, there are various consultancies that I'm seeing you've been doing. You are teaching, you know, various institutions of higher learning, which again is all right. Again, you know, advocacy, where you know, doing advocacy for people, but also at the same time also litigation. So I don't seem to get where exactly is your skills being applied in a very specialized manner, in line with what I just told you about how to lead.
Yes, yes, Commissioner. I would say in academia, I have focused a lot on constitutional law and human rights. And that is a space that I do my academic work. When it comes to practice, I have specialized in dispute resolution. So I've handled multiple types of disputes in statutory tribunals, in our magistrates' courts, in the superior courts. And so I still see myself as a person who has focused on key areas where I'm able to give my best, Commissioner.
So, which leads me now to the final question. If somebody was asked to define Dr. KhaKula,
Yes.
will you be defined as an academician? Will you be defined as a litigation lawyer? will you be defined as a consultant? What is it that somebody will describe you as in one sentence?
A legal practitioner.
All right.
Yes.
All right. That's all.
Yeah.
I'll take that conversation further by bringing you squarely to the High Court where you practice. And as you have been told, this is a very complex job, or should I call it a calling, because you will have to work beyond the call of duty. When we engage the stakeholders, they told us to look for actually a tractor. And we want to know whether you are that tractor. Yes.
My lady, I didn't quite get your question.
Yes.
You said stakeholders.
Yes, the stakeholders told us to look for a tractor.
A tractor.
Because of the complexities.
Yes.
That you will face in the High Court. So let me be specific. There are many types of jurisdictions exercised in the High Court. I want you to give us 5 key jurisdictions of the High Court.
Now, my lady, the first one is appellate. The High Court is an appellate court. The second one is the court has both unlimited original jurisdiction in civil and criminal matters. It is a constitutional court. It interprets the Constitution. It is also a human rights court in the sense that it enforces the Bill of Rights. It is also an election court in cases where statute has given it jurisdiction to do so.
Okay, I'm happy with that.
Yes.
Another area that we are challenged is the protection of rights, of the fundamental rights. And we would like to hear from you the areas where there are challenges in accessing justice to protect those fundamental rights, and what you would do as a judge to ensure that there is confidence in the judiciary.
I think, first of all, one of the biggest challenges in our Constitution is breathing life into Article 43, which are social and economic rights. These are rights that directly improve the lives of Kenyans, rights such as health, rights such as education, clean water, etc., etc. As a judge, then, I would seek to give life to these provisions in appropriate cases. I would seek to involve other stakeholders in government or other arms of government. And that has been the dilemma, to the extent that internationally some countries have said those are not human rights. But in our country, they are in our Constitution, they're justiciable, and therefore as a judge I will find creative means to ensure that the other arms of government that are responsible for example, creating policy that will give life to these parts of the Constitution actually do their bit through my rulings and judgments. The second thing is...
how would you engage them for purposes of enforcement of your orders?
I think one of the ways in which these orders can be enforced is through structural interdicts, where you allow the appropriate arms of government to go and formulate policies and report back to the court after a given period, and the court will assess whether those policies are actually reasonable or not. So you apply the reasonableness test.
Okay.
The second thing that I would do is I would ensure that each and every Kenyan has access to the courts. And so if it's somebody who comes to court and they're not represented, I would find a way, because sometimes I've seen the dilemma in courts is that you have this old lady who is trying to articulate her issues in court, but she does not know how to present her case. She doesn't have the technical expertise that a lawyer perhaps has to design pleadings and present them before a court for determination. So I'll be very sensitive to such things and see how best I can assist Kenyans who need help to access a court for purposes of justice. I will not be quick to close the door because they have not come in the proper way, because they have not filed a plaint. But I'll find a way of opening the door so that they come in and have their issues articulated. Even if it's to find a working relationship with an NGO that supports people who need legal services, would create those partnerships. Mm-hmm. And I believe that, reading your vision, my lady, you want judges who will be able to create local solutions to local problems. So I believe that I'll be that judge who would find a local solution to a local problem.
Thank you very much. The next set of questions will be asked by Justice Majanja.
Thank you, Chair, and good morning once again.
Good morning, Judge.
You said you practice in Nairobi and Bungoma.
Yes.
Have you attended a CUC meeting in Bungoma?
I have not attended a CUC meeting in Bungoma, but...
have you attended a bar bench meeting in Bungoma?
No, I haven't.
Have you attended a CUC meeting in Nairobi?
Nairobi, my associates have. I haven't done it.
Have you attended a bar bench meeting in Nairobi?
No, I haven't, Judge.
Okay, don't you find that very strange?
Sometimes because of the exigencies of work, I would want to delegate, and the person who attends the meeting would come and report back to us.
Okay.
Yes.
So let's look at Bungoma.
Yes.
Who is the presiding judge of Bungoma?
It's Justice Kimei.
You are sure?
Yes.
And since your delegates report to you, what is the most pressing issue in Bungoma locals now for advocates?
The issue of backlog.
Apart from backlog, it's a common issue.
Another issue is sometimes we experience problems with the CTS system, where perhaps it's not functioning for a day or two.
Okay.
And maybe we have
another issue that is peculiar to Bungoma locals.
I think another issue is sometimes we have cases where there's no progress being done because lawyers are not proactive on their cases.
For example, you've not had complaints about the state of the buildings in Bungoma locals. That has not been an issue.
It has been an issue.
So you want to be a judge, yet you have not been following up issues that concern administration of justice.
I think I have not been very keen on that in terms of because I haven't gone to the courts to see what the issues are. I can say, Commissioner, I have not been very keen on that.
Thank you. I have no further questions for you.
Thank you.
Thank you, Honorable Chair, CJ. Daktari, Council,
yes,
I have a few questions for you.
Yes, sir.
I have basically looked at your writings. There are quite many of them are the ones that relate to your thesis and so on. Are very academic. I'm also interested in your sample writings in respect of your pleadings and also your submissions. I find that from a lawyer standpoint, you have done them very well. They're structured and to the point. But now you'll be asked to be writing rulings and judgments, orders and decrees, which are quite a different ballgame. What is the difference between a judgment and a ruling in terms of definition?
Thank you, Commissioner, for that question. A judgment is a final pronunciation or pronouncement in a matter. It finalizes a matter. And once a judgment has been issued, the court is functus officio unless the parties come back to the court with an application for review. Meanwhile, a ruling is what I would call a part judge because it deals with an interlocutory matter within, it does not fully discharge the matter. It deals mostly with interlocutory applications. Yes.
During the proceedings?
During the proceedings, okay. Yes. That's the difference.
If you become a judge and you've had a matter, looking futuristically, how would you intend to structure your judgment? What are the features of during the construction of a judgment, what are the main basic features of a judgment?
The basic features of a judgment include one, the introduction, where you cover the background of the dispute. The second part is where you analyze the submissions of the parties, or you also analyze the evidence that was presented. You analyze the submissions of the parties. Then you proceed to analyze the law as you do your disposition. You compare the evidence, the pleadings, and the issues that arose. At that point, you have already identified the issues, and so you connect them to the law, and then you come to your conclusion where you make your pronouncement.
Okay.
Yeah.
Now, when you are writing, during the course of writing the ruling of judgment, who are you intending to communicate with? Initially and in finality.
I've had cases where our clients have come to my office, especially in Bungoma when we are serving clients who are from the village. And the reason why they come is they want us to read a judgment for them because it is too technical. So in my understanding, I think a judgment, your audience is actually just the Kenyan in the streets. That is your primary audience. The litigants themselves, the people who own the case. Most likely it's just normal people who perhaps have a very average education. So you must be able to write a judgment that that person can read at least and get a basic understanding of what the court is saying. Judge, to answer your question, I think my primary audience would be the Mwananchi in the streets.
Yes.
Yes.
You are an academician at a very high level. Would you be able to write simple, clear judgments that have that impact, that they talk to the litigants and finally to society?
Judge, I believe I am able to write those kinds of judgment. Because even in academic writing, you must understand your audience and write something that your audience will be able to understand. So if I am writing a paper for LLB students, I would use a different kind of approach if I'm writing a paper for, so you must understand your audience. And Judge, I believe that I'm able to write and communicate clearly to my audience. Yes.
So you'll not use the legalese language, null and void ab initio, and
they are not necessarily bad words, or I would use the language, but again, I think after saying void ab initio, for example, to use what you have said, I would break it down further to just say what I mean, and say, break it down so that it doesn't stop at void ab initio, but break it down in English, simple English, for somebody to understand what that means.
Thank you very much. I wish you all the best.
Thank you, Commissioner.
Thank you, Chair. Good afternoon. Good morning, sorry, Council.
Good morning, Commissioner.
Okay, I have
Your
a few
Honor.
questions for you. Why do parties in a civil case intend to amend their pleadings? What would be the intention of parties in a case the intention of parties to amend their pleadings?
Commissioner, thank you for the question. Most of the time it would be to bring in an aspect that was not captured originally when the matter was filed. So an amendment would seek to correct an issue that was not captured. Sometimes certain things have changed within the dynamics of litigation. For example, we filed pleadings to stop an auction. The court refused to give us an injunction. The auction happened. We'd need to amend our pleadings so that now we see how to get justice. Perhaps say we want compensation for the property that was wrongly auctioned. So those are some of the reasons as to why parties would amend their pleadings.
Okay. Now we have two conflicting decisions from the High Court with regards to whether you can amend an application. Which one would you go for? You can't amend an application, or you can amend an application and give your reasons?
I think I would go with the school of thought that it is not good practice to amend an application.
Give the reasons.
The reason for that is that an application is an interlocutory proceeding before a court. And so if there was something that you did not capture in your initial application, I think the proper thing is to withdraw it and just file a proper one. There's also been a debate on whether a pleading, an application is actually a pleading.
It's you, you're making you're giving us your response.
Yes.
It's for you to now.
So for me, I would go with the practice of withdrawing and filing a proper one.
But your initial question, your answer to the question, why do we need to amend our documents? It was more of clarity. So you don't think at times you may need to clarify something that you have left out in an application?
You may need to do that. I agree with you.
So your response is, can you amend an application, or you cannot amend an application?
I believe you can file a proper one, capturing what you had missed out.
So you withdraw and file a proper one?
Yes.
Okay. So what are the 3 essential elements of the offense of obtaining by false pretense?
The essential elements would be, 1, that a person purported to be, presented himself as being able to give you a certain kind of service. Number 2, they received some consideration. And number 3, they did not deliver.
Are you sure about that? You'll have to read.
I may have to check on that.
Okay.
Yeah.
Lastly,
I may have to check on that.
When the Chief Justice asked you a question with regards to what you would do to enhance access to justice, you mentioned that when a party appears before you and they've not filed a plaint, you will ensure they get legal representation. Take us through how, as a judge, you will ensure that that party who has not filed a plaint gets legal representation.
One of the ways that I can do that is to raise the issue, for example, in a bar bench meeting or a CUC meeting, and perhaps have a conversation with lawyers who practice within that station and request some of them to take up such a brief to assist this person to be able to access the court. I have had an experience in court where, I can't remember the name of the judge, requested me to help a litigant who could not articulate their issues to court, to find a way of helping them. And indeed, after that court session, I was able to help this person to draw whatever document they needed to draw. So I would engage, I would do that. I would use that strategy. Look at the available resources around me and
so you'll engage a bar bench meeting, reach out, the lawyers say they will not be able to take up that matter pro bono. They are no longer interested, they want to be paid.
I believe lawyers, I cannot miss a lawyer who will take up the matter, because I practice, and I know that most of the lawyers out here also they would want to give back. So I don't entirely believe that all the lawyers will say we cannot take up this matter.
So would you document in your file the proceedings? Because I don't even understand how a person who has not filed a plaint, there will be a file before you with no plaint. Because that is the example you cited. A person who is not able to file a plaint, I will refer that person for legal representation.
That was just but an example. Perhaps it was not very accurate, but perhaps what I had in mind is there are certain suits that would require specific pleadings to be filed. For example, if they were required to file, let's say, an originating summon, and they have come by way of plaint, or vice versa, and I have identified that that is the problem, then of course I would have a file before me, and if it's a person who is representing themselves, then I will tell them that the process in which you have used to come before the court is wrong.
Are you sure you are allowed by law to tell a party who has wrongly come before you in an adversarial system that you ought not to have come by way of a plaint? Go and look for a lawyer to bring the necessary pleadings, the correct pleadings, not by plaint, by originating someone. Are you allowed? How are you supposed to communicate? with parties to a suit.
And I'm using an example of a person who is representing themselves.
It's still a party to a suit.
A party to a suit.
Yes.
Yeah. And I'm getting my inspiration from Article 159 of the Constitution, where courts are required to exercise substantive justice. You know, look at how a dispute can be resolved, rather than being fixated on procedural technicalities. So I would find a way of communicating to the
How?
litigant.
That is what I'm asking you. How do you communicate as a judge?
Yes.
How are you expected to communicate?
Commissioner, I think I may need to think about that.
Okay.
Yeah.
Thank you.
I may need to think about the issue of communicating. But I believe there's a way in which I can communicate.
But how are you expected as a judge? You know, that's what I'm trying to get you to give us a response.
Yes.
How are judges expected to communicate?
The judges are expected to communicate primarily through their rulings and judgments.
Thank you.
Yeah, that is how they're supposed to communicate.
Thank you, Chair, and welcome again, Andrew. Now, could you explain how the role of the judge today has changed from that of a traditional judge as we have always known it?
I think the judge today is required to be very sensitive to the fact that justice, one, is about people. The judge today needs to be connected to the ongoing things in the community. The judge today needs to be technologically savvy. They must be able to leverage on technology for efficiency. The judge today, I think those are the ones that stand out for me.
Mm-hmm.
Yes.
Okay. Finally, could you explain to us the independence and the interdependence, you know, three arms of government, how they work independently and interdependently?
So, when it comes to the independence, let me use the independence of the judiciary. It means that the judiciary is not under direction from other arms of government. It means that judges and magistrates and judicial officers have discretion to deal with matters without taking instructions from anyone. They have to pay due regard to the law and make decisions. However, when I look at the constitutional architecture that we have in this country, we cannot then say that the judiciary is 100% independent, but would rather say that the judiciary collaborates with other arms of government to achieve the broader objectives in the Constitution, which is delivery of justice to the people of Kenya. So there's a level of interdependence, and I'll give a practical example that the judiciary has to go to the National Assembly to approve funding to be given to the judiciary. So that's a level of interdependence. I also see interdependence within the NCAJ, which is a body that constitutes different stakeholders in the justice sector, some of them from the executive, some from the legislative arm of government. And so the idea is that justice is a concerted effort. So as much as there is a principle of independence, our constitution also creates a framework through which all these different arms of government must collaborate, must work together to achieve certain constitutional objectives. Yeah. Yeah.
Thank you, Chair. Good morning once again.
Good morning, Commissioner.
You currently have a law firm, one in Bungoma and one in Nairobi. How many? In both offices? In total?
In total.
Yes.
I work with 4 associates.
4 associates?
Yes.
And staff members, roughly how many?
Staff members, we have about 12.
12 staff members.
Support staff, yes.
Do you have a performance measurement framework in your law firm?
Yes, we designed something last year where we set goals. We agree with the different process owners that this is what we want to achieve, and then we review the goals after a year.
How has that seen performance in your law firm?
It has enhanced performance in the sense that people feel directly accountable for certain things, and it has pushed those who did not want to improve themselves to actually improve because they know that they're going to be assessed. And at the same time, we were able to see productivity. We're able to gauge somebody's productivity. We're able to also stir a culture of improvement in the way that you do your work. So it has positively impacted our deliverables. Yes.
What other way has it benefited the firm other than improving productivity and motivating staff to work?
It has also improved our revenue. Because for me, like the lead partner, I also set goals for myself. So last year, some of the goals that we set were to bring in X number of clients. And I think I did like half 50% of it. And I was happy with myself that I was able to set a goal and at least deliver.
For a moment there, I thought you were going to quote figures of
no.
the amount of money that
No-
it has
no
brought in.
commissioner.
Yes.
Yeah.
It
But
also
definitely.
helps. It also helps to give you information on areas of improvement and how you can support your staff.
Correct.
Yes.
Some of the areas that we have identified out of that process is continuous training for the staff. So we've identified certain areas that we must get experts to train us this year, for instance, where staff have said, yes, we do these assignments, but it seems like we have gray areas on ABCD and would like to improve our competence.
Okay, great. Now, the second question I want to ask you, in a criminal case, how would you go about pre-trial case management and what would you be looking to achieve?
I'll start with what I'll be looking to achieve. What I'll be looking to achieve is to get the matter ready for hearing. Now, the process.
Always?
Yes, to get the matter ready for hearing. But also, the second aspect of that would be also to see whether the matter can be resolved out of court.
Okay.
Yeah.
So how would you go about it?
So I would, first of all, ensure that we have all the documents that are required to be filed. That is witness statements, exhibits, etc., etc. We know how many witnesses are being called. We know whether there are any experts that are being called. Perhaps we even get an indication of how long it will take for all these witnesses to be heard. And I think so once we've done that, then we have a clear way forward on how the matter will progress after that.
Okay, I will take that. I want to give you a scenario, a practical scenario, and I hope you will give us practical solutions to what you may find yourself in if you are ever to make it as a judge. So you are appointed a judge and you are posted to a station where you find that you are the only judge and you have to handle all cases. It's only in Nairobi, I think, and some major stations where we specialize, but mostly in the outpost stations, you'll find you handle everything. So you find in your docket you have about 4,000 cases. About 50% of them are already backlogged, dating back to over 3 years. So how would you go about addressing or handling these cases, bearing in mind that we are backlog clearance is one of the issues that we are grappling with?
Yes. Thank you, Commissioner, for that question. When I report to that station, I believe, I haven't used the CTS from the judiciary's end, but I believe in that system, I'm able to log in and see how many matters are allocated to me. I believe that the system is able to, for example, generate a report with an aging
yes, I've already
with
given
statistics.
you have 4,000.
Yes, I
You've
have.
seen it in the system,
So
you have 4,000.
what I'll be looking for is to sort of understand which files are very old among the 4,000. I will focus on that, on the older files, perhaps the ones that are older than 3 years. Focus on them. I will want to find out why these cases are not proceeding. I will want to find out why the advocates are not taking dates for hearing. So if it's an issue that perhaps pretrial has not been done, I will focus to get that done. If it's notice
When
to
you
show
say
cause,
focus, you know you're speaking in a very general sense. When
Yes.
you say focus means what?
focus is basically ensure that the process of pretrial begins. We put a date on the matter. If the date has not been taken by the law firms concerned, we'll issue a notice
Yes.
that this matter is coming up for mention on a particular day for purposes of pretrial. On that day, I anticipate that a lawyer might come and say, this matter was resolved. I anticipate that a lawyer might come and say, yes, we are ready to take pretrial directions, so give us another 14 days to put in our bundle of documents, our witness statements, etc., etc. I anticipate that another lawyer might come and say, this is a matter that looks like can be resolved through mediation. And I would even prompt and ask whether this is a matter that can go for mediation. If it's one of those, we'll refer it for mediation. I anticipate that there are matters that can also go to AJS, which I will facilitate the process, and then get the system running, you know. If it's a matter that needs to be heard, then we prioritize the hearing and get it heard. We make sure that we have all the bundles of documents filed, witness statements, and so when it comes to hearing, we are not taking a lot of time, but we are making progress on the matters.
So that is the focus you will give the old cases, the 50% I've told you?
Yes.
Yes. So what happens to the new ones?
The new ones, I would also seek to look at the nature of these cases. Some of them might have some interlocutory applications that perhaps can be dispensed with without necessarily writing rulings and judgments. So we'll have that engagement with counsel in court. So in situations where, for example, we can agree that let's have an order for status quo and let us focus on the hearing, we'll prepare the matter for hearing and get it moving. If it's a matter that indeed needs me to sit down to write a ruling on an interlocutory application, then I'll ensure that parties have filed their submissions and I'm ready to write a ruling or in the matter. Those are the strategies that I would employ. Because when I think about 4,000 files, I don't look at them as bulk 4,000, but I need to understand what exactly is in this 4,000 files. Yeah. And
so
when I get into that
all
inquiry,
that, you find you have about eliminated about 3,000.
Yes.
I mean 1,000, so you have 3,000 pending.
Yeah.
1,500 new, 1,500 old.
Honorable Commissioner, as court proceeds, then I will be very firm about proceeding. I will not entertain a lot of adjournments.
So you'll proceed with them simultaneously?
If my diary allows me, I'll make sure that each matter proceeds on the day it comes up.
Okay.
Yeah.
Lastly, if you're successful to become a judge, you will find your life will change somewhat. Your social life will be more restricted. You'll be expected to work in the evenings, late in the night. You'll be expected sometimes to work on weekends and even when you're on leave, because of the scenario I have just explained to you. If you're going to be handling the old and the new simultaneously, you will find you're forever having files everywhere you go. You'll be expected to accept probity into your life, your financial status. You're forever declaring what you have acquired, what you own. You'll be expected to lead a very restricted life in terms of the friends that you keep, to be accountable to what your family members do. You may find that you're transferred away from your areas of comfort. You probably operate majorly between Nairobi and Bungoma. You may find yourself in Malindi. Are you prepared for that kind of life?
Commissioner, I am prepared for that kind of life. I understand the nature of this office and what it comes with, and I have done a self-assessment. I have reflected. I have talked to some of my mentors in the profession, and in my mind I'm clear that I'm judge ready. I'm ready to take up the assignment and work. I have spoken to my family about the possibility of life changing, and we are aligned, Commissioner. I understand the depth of this office and what it comes with.
So you're all prepared to make the sacrifice?
I am judge ready.
Thank you. Thank you, my lady.
Thank you very much. CJ. Wakili, now the responsibility you are asking for will include leadership of other professionals. I would like to know from you in your career, what can you describe as your key achievements as a leader? That is, specific achievements that can be attributed to you.
As a leader, I think one of the things that I am proud of is the fact that I am a team leader in my place of work. And we set goals, we achieve goals. I have managed to inspire people to work. Honorable Commissioner, people get paid at the end of the month because we all work. So I believe, I'm proud of that as a leader, that I'm able to put together a team of people who are able to get aligned and achieve certain objectives. I'm able to inspire people to work. I am also visionary in the sense that I'm able to see what we are doing in the short term, in the long term, and prepare the team to handle the long term. So I think those are the qualities that I would bring as a leader.
I wanted the specific achievements that can be attributed to you as a leader. Specific achievements.
Yes.
Do you have any?
And the specific achievement that I've talked about is I run a law firm that pays people's bills. I support families in the law firm. Yes, and I think if I wasn't a good leader, then I don't think I would have even people working with us in the team. So I call that a specific achievement as a leader.
Okay.
Yeah.
What would you term your leadership as? Is it visionary? Is it also then transformative? What is it?
First of all, I'm what I call a servant leader, in the sense that I would be on the front line doing the heavy lifting. I am also a visionary leader because I am able to predict outcomes and trends within perhaps the industry, and also create strategies that would enable us to do even better. So in that sense, I am visionary.
As a transformative leader, do you have any specific activities you have undertaken that can show that transformative skills?
I have, I just want to say that I have also been nominated and I've received awards within the profession. For example, last year I won an award for legal journalism award. Legal journalism award within the legal profession for my publications and writings. And I think that is transformative because I am also on the front line when it comes to publications and research and writing. I have also recently published a book which I submitted as part of my sample writings before this commission, a book on social economic rights. I don't think there's anyone else who has written a book such as that in the country currently. So I look at these achievements as transformational.
Okay, thank you.
Thank you, Honorable Chair. Daktari, in Chapter 6 of the Constitution, what are the guiding principles of leadership and integrity?
The ones that I can remember are that leadership is about the people. It is a position of trust, and therefore one must exercise leadership with that in mind. The other attributes are integrity, transparency and accountability, involving people in the process of decision making.
Guiding principles of leadership and integrity. How is integrity one of them?
Yeah, sorry, Commissioner, I think they might have flown off my mind, but I have read Chapter 6.
Do you know the reasons that are grounds for removal of a judge? Please give us those.
Incompetence is one of them. Corruption is another one. I think a situation where the judge is unable to function in the office of a judge, or give the function in the office of a judge. I think those are the grounds. Gross misconduct, a violation of the Constitution. Yeah. those are the ones I can remember, Commissioner.
Okay.
Yeah.
All right. Thank you. That's all from me.
Thank you very much, Council, Dr. KhaKula, for engaging with us this morning. That brings us to the end of the interview. But we always give a candidate an opportunity to say something or ask a question.
Yes, first of all, I think I would just say thank you very much for allowing me to appear before you today. Indeed, it's been an honor. I had a suggestion to make in regard to how to even leverage on technology to make our processes better. I was thinking about using artificial intelligence to do Order 11, which is pre-trial, so that we free our deputy registrars, we free our judges from that activity. I believe it's something that can be programmed where lawyers can put in answers to questions. Have you filed your witness statements? Yes. Have you uploaded your bundle of documents? Yes. And then AI generates a certificate, and we move to other processes.
That's why the judge was engaging you
Yes.
on why you are not an active member of the bar
CUCs.
bench and the CUC,
Yes.
because that's where you give those suggestions.
Yes.
So that the particular stations where you're working, they can engage with the AI to make themselves more efficient.
Yes.
But that's a good idea,
Yes.
well taken, and the advice is that please take it to the court user committees.
Thank you.
Yes.
Thank you, my
but
lady.
Thank you for your time.
Thank you very
We
much.
wish you well.
Thank
We
you.
will get in touch when we complete the process.
Thank you very
All
much.
the best. Keep up the good work
Thank you.
that you do with your law firm, inspiring many people and also the community.
Thank you, my lady.
Yeah.
Yeah. Have a good day, commissioners.